Are paid 15-minute breaks required by law under Colorado labor law?
Colorado employees seek out the answer to this question with high frequency for good reason.
Colorado is one of the states that has a labor and employment law that requires many employees to receive a paid break at work and gives employees legal remedies when employers refuse to provide legally required paid breaks. In this post, we will discuss some of the legal issues around Colorado's paid break law and when you might need to talk to an employment lawyer in Colorado if you do not receive paid breaks required by law. Before getting into those details, let's get to a brief answer under Colorado law about paid 15-minute breaks. Under Colorado law, non-exempt employees are entitled to paid 10-minute breaks every 4 hours of work but not entitled to 15-minute paid breaks. Employee break laws involve both federal and state law, so let's take a look at how each affects employee rights to unpaid and paid breaks. Federal law on paid breaks for employees. Federal law does not require paid breaks for employees but establishes minimum standards for whether breaks are paid or unpaid when they occur. The federal employment law that applies to most employees on the subject of breaks is the Fair Labor Standards Act. Under the Fair Labor Standards Act, employees are not generally entitled to break periods at all. If, however, an employee receives a break period of less than 20 minutes, then the employee must be paid for that break time. An important caveat under the FLSA applies to mothers who need break time to express milk. The PPACA created a specific break rule in this situation. The PPACA amended the FLSA under 29 U.S.C. Section 207, R.1, to require reasonable break time for mothers to express milk. Under the FLSA amendment, the break period for expressing milk does not have to be paid. However, if the employer provides breaks under 20 minutes and that break time is used for expressing milk, then it must be paid like any other paid break under FLSA. Federal law provides for a wide range of unpaid break or rest periods to employees under different circumstances. These include Family and Medical Leave Act, FMLA, covered leave. Leave is an accommodation for a disability. Required rest for transportation workers, and pregnancy leave under the Pregnancy Discrimination Act. The FLSA does not require employers to provide unpaid rest periods for lunches, but if an employer provides a rest period greater than 20 minutes, then it is not required to pay for that time so long as the employee is truly relieved of all work on behalf of the employer. Colorado labor and employment laws on paid breaks. Colorado law specifically requires paid and unpaid break periods for employees covered by the state wage law. Colorado has other state laws that require unpaid break periods for particular purposes like family leave or as an accommodation for a disability. But let's focus on how Colorado law expands on the FLSA for both paid and unpaid break periods under the normal workday. Like federal law, Colorado labor laws protect break periods for employees covered by the state wage law. If you are exempt from this law, then state law does not require employers to provide typical break or lunch periods. Most employees are covered by Colorado wage law under the Colorado Wage Act, found in Title 8 of the Colorado Revised Statutes. An employer can require the employee to stay on work premises during the paid 10-minute break but not during the longer unpaid lunch period. Putting federal and Colorado paid break laws together. Note that the Colorado Wage Act and the current minimum wage order do not require paid 15-minute break periods, although 15 minutes is the standard break period for many employers. If an employer provides a 15-minute break period, then it must be paid for covered employees under the FLSA. But the employer only has to provide a 10-minute period for covered employees under the Colorado Wage Act. Putting the two together for an employee covered by both federal and state minimum wage laws. The employer must provide a paid 10-minute break every 4 hours. The employer may extend the break period to 15 minutes. If the employer extends the break period to 15 minutes, then it must be a paid 15-minute break. If you work under an individual employment contract or a collective bargaining agreement, the contract or agreement may provide additional requirements for rest periods. Remedies against a Colorado employer for violating paid break requirements. Federal law. Federal law only requires employers to pay for breaks of 20 minutes or less, so when employees take these breaks, they must count as compensable time in the day worked. An employer who fails to count compensable breaks within the workweek is liable for unpaid minimum wage and overtime pay, as appropriate. Colorado law. If the employee receives the required 10-minute breaks but the employer does not include the breaks within compensable time, then the employer is liable to the employee for unpaid wages and overtime pay, as appropriate, for the 10-minute breaks. However, if the employee does not receive the breaks, then the employee can pursue the employer for claims related to this violation of the minimum wage order. Employees may not have tremendous claims if the employer only does not provide the required paid 10-minute breaks, but an employee could nevertheless pursue a claim for the violation. If the employer takes disciplinary action against an employee who demands due paid breaks, then the employee may have a stronger claim against the employer for the effects of the disciplinary action. Employees have successfully sued for wrongful discharge in violation of public policy when employers terminate employees in retaliation for demanding the legally required break periods.
Talk to an employment lawyer in Colorado about your employee break rights.
If you believe you are not receiving required break periods or not being properly paid for your breaks, then you should talk to a Denver employment lawyer right away.
Wage-based claims carry a statute of limitations period that applies to each pay period, so delay working on your potential claims may limit your right to recover due wages.